Hello, and I'd like to introduce Dr. Catherine O'Rourke, who is here today to very generously speak about her involvement in the Feminist Judgment Project, the Northern/Irish Feminist Judgment Project to be specific. And I think it would be really helpful to begin, Catherine, if you could perhaps give a bit of background to your involvement in that project.
Sure, yes. I'm really happy to do this, and hello to anyone who's listening. Hello from Belfast. So the Northern Irish Feminist Judgment Project was led by Mairead Enright, Aoife O'Donoghue and Julie McCandless, who are all based in English universities. And they initially just put out a tender to see who might be interested in rewriting a judgment. And I had a particular bee in my bonnet that I was keen to rewrite, and then ended up being fairly involved in the project organization. So we hosted the first of the drafting workshops at Ulster University, and then I was also quite involved in disseminating the project. So we ended up getting quite good engagement with the judiciary in Northern Ireland. Because interestingly, just as we were concluding the project, finally the first two women were appointed to our High Court. There'd been no women on our High Court ever. And those two women became real champions of the project, and indeed our Chief Justice here as well. So so involved really throughout. And now we're engaged in a feminist constitutional futures project where we're trying to bring some of the feminist judgment making methods to constitutional debates going on at the moment around Northern Ireland, Ireland and the UK.
I'm really interested in the involvement of the women justices who were appointed at that time. Were they seen as feminist women judges at the time of their appointment?
So it's interesting. No, I think it's fair to say that they wouldn't necessarily have been known as feminist champions. So in the English and Welsh project, they had gone quite in judgment with Lady Hale, but Lady Hale had, of course, I think really kind of styled herself as a feminist judge, which would not have been true of the women who were appointed in Northern Ireland. That said, what they both said and said publicly was that they saw how important it was for the community that finally there were women on the High Court. And I think that they were surprised by that, but they were very happy to take up that role, which I was interested in. They said that they recognized that actually for the community it meant something that we finally had women in our senior judiciary.
I think that's really powerful, and a really powerful one about not conflating women and feminists, but also so helpful to have the champions in the judiciary supporting projects for more gender sensitive approaches to judging, because there can be some backlash sometimes.
Yeah.
And I think one thing that I'm interested in hearing about from your perspective as a contributor, so I understand that you rewrote the judgment in rewrite. And I think that one of the things about writing judgments is that stepping into the judicial role and actually having to write something that resembles a legal judgment and is plausible as a judgment and also reads as feminist, that's a pretty big ask. How did you confront that task?
Yeah, you're right, and it does sometimes feel in tension because, obviously I think the contribution of the Feminist Judgment Project is that we imagine a different kind of legal universe, a different way to interpret, a different way to determine, relevant facts and to contextualize judgments and then to interpret and apply the law. But we also hope that we'll be read by our kind of legal colleagues and be taught, and so it can be in tension. So I think, well, I suppose maybe to start with the first piece about the judgment writing, because in lots of ways, I was very accustomed to doing feminist legal work. I was much less accustomed to writing judgments. One of the things that was helpfully done quite early on, and actually this was before the Northern Irish Feminist Judgment Project, I went to one of the teaching workshops from the coming out of the English Welsh project. And one of the things that they really emphasized in that was trying to demystify a little bit judgment writing. And they said, look, essentially, you've got you're condensing the facts, right? You're identifying the relevant facts. So you're sort of telling a story, and then you're contextualizing those facts, and you're doing lots of things that actually are familiar to you. So there was a real emphasis on trying to demystify that a little bit, and I found that helpful. And actually, I worked pretty closely with the framework of the original judgment when coming up with my own, because those were useful guardrails, I think, for the project for me. But then as I went on, I didn't know going in really whether I was actually going to change the outcome. I was very keen that the judgment would be differently framed, you know. But then ultimately, actually, I think I really kind of grew into the my judicial role and really sort of started to have fun with it. And as academics, we're so careful about, you know, we double and triple cite everything. We're so careful about showing our evidence base and our rigor and our supporting evidence for our claims. But judges just get to say stuff, you know. It's just sort of remarkable. It's such a different way of writing. And ultimately, I ended up actually quite dramatically reversing the judgment. I came to entirely different conclusions. And it was part of the process of growing into the role of being the judge that really kind of allowed me to do that. That I just said, well, look, here's me applying my judicial common sense to this set of facts and to this scenario. So yeah, so I think the process was quite important. I'll say it was a process and a useful one. And then as to the feminist part of it, I mean, I did, you know, obviously with the drafting workshops. So we had initial workshops before we even got into the drafting workshops, and a lot of those were about the method and methodology. And we had lots of generous input from the folks who had done the work before, particularly, you know, Rosemary Hunter and Claire McLean and Erica Rackley. They were very supportive and very practically helpful to us. The key thing. So I mean, I applied the method. You know, so in terms of the facts, I mean, actually trying to tell the story a bit more of the applicant was a first thing I did, because obviously in the initial judgments, you know, there's this kind of one sentence, you know, the nationalist resident of the Garvaghey Road. So actually what I tried to do a little bit in my judgment was to tell the story of what it meant to be a woman living on the Garvaghey Road when parades were happening, because that's completely overlooked or not detailed at all. And then I think the main thing though I did was about how you contextualize the facts and particularly drawing on other disciplines. So I went back and so my judgment was about the regulation of parading in Northern Ireland, and a challenge to the fact that no women had been appointed to the Parades Commission that oversees parading. And in the original judgment, the judge is very dismissive of the application and says, you know, we all know that parading in Northern Ireland is about ethnic identity, and you know, so it wasn't a hard judgment to rewrite in that sense. But what I did do was go back and actually look at the history of parading in Northern Ireland, and I drew out the fact that there's pretty good historic documentation of the fact that there was, you know, it's always been lots of women in Northern Irish parading, also women who self-organized both within ethnic groups, but also the fact that as parading had evolved in Northern Ireland, increasingly parading wasn't necessarily about ethnic issues. It was trade union movements, again, lots of women in them, Women's Day marches. Even now, actually, our largest parade is Pride. So drawing on that, I found that sort of going back, kind of giving that kind of historical context, which of course the original judge paid no attention to, being quite useful. And then I think challenging the judicial common sense of the original judgment, and that sort of judicial common sense that, you know, we all know that parading is about ethnic identity, and so the obligation to be representative of the community refers to the two ethnic communities. Actually, just in light of having told the story of the applicant, contextualizing the parading in a different way then led me to a very different sort of judicial common sense around what representation mattered when it came to constituting our Parades Commission.
Did you use the same kind of judicial common sense language we're accustomed to? We all know that. Did you replicate that?
I know. I mean, I was careful not to. I mean, I just felt. I mean, I found it so obnoxious in the original judgment that I was careful not to. And I mean, also, I suppose this is where your academic training comes through. But because I had already told the story differently, it was, you know, I sort of led to my conclusion that actually, when we talk about representatives of the community in the context of parading, you need to be attentive to these other identities as well. So no, I resisted the urge to say we all know that. Though maybe I implied
that framing. Did your thinking about what constituted a feminist judgment evolve over time? I note the extraordinary work of Rosemary Hunter and others, and in particular Hunter's checklist about what constitutes feminist judging, and it's not supposed to be an exhaustive list, but it's a kind of useful checklist. Were you guided by that framework?
Yeah, absolutely. I mean, we did take it on quite directly, quite literally. We used it maybe not as a checklist, but as I say, as guardrails, that provided quite clear parameters on the project. And we were, throughout, I think we were very conscious of the fact that there were antecedents to our project and that there would probably be successors. And we did very self-consciously locate ourselves within the tradition of feminist judging that had, the Women's Canadian Court, the English and Welsh project, and ours. So we were, I think, very happy to embrace that. I think the things that were probably distinctive about our project was there was definitely more of an emphasis on, I think, the arts and humanities. We made more of an effort to engage with artists throughout our judgment writing, though it had its challenges, I think, too. I mean, and then the Scottish project went well beyond that in for us as well. And then the other thing that was, obviously the thing that was distinctive with us was the fact that we had these two jurisdictions. So we had Northern Ireland and the Republic of Ireland. And the other aspect I think that was probably distinctive was the question of diaspora. So I mentioned that the 3 project leads were based in English universities. And actually the nature of sort of the legal academy on these islands is that's sort of still the case, that most of the Irish feminist legal scholars are in English and Welsh universities. So those were all sort of different dynamics to ours, but ones that ultimately I think enriched it. And I think it's quite interesting to see as the method is applied in different contexts and settings. And I would say the thing that surprised me most was just ultimately how feasible it all was. I think actually we weren't sort of redefining the whole universe of judicial reasoning, right? We were coming up with missing feminist judgments that might have been there in the first place had judges made different decisions.
That's something I'm really keen to unpack, actually, this kind of tension between, as I see it, one of the strengths of the feminist judgment methodology is plausibility, that it could read as a legitimate judgment, and that's really important. And then on the other hand, you have the Lord sense of the master's tools will never dismantle the master's house. Is this a lost opportunity to put on our most radical feminist hats? Was there a sense of that tension in your project?
So, I mean, I think this is a tension that maybe runs through all feminist work. So, yes, I think there were. I mean, I know actually even just a practical thing for me was that my expertise really is international law and human rights and public international law. And there was an intervention from our Human Rights Commission into the judgment that I rewrote, and that brought out the international obligations. And Justice Carswell, I mean, incredibly dismissively said, basically don't waste my time with this human rights stuff. And I definitely was tempted to write this really developed international law-based new approach in my judgment. And ultimately I just decided this is not how the Northern Ireland High Court deals with international law. And in that sense, I don't think it's going to necessarily be useful to say that the only way that you can reinterpret this judgment in a more positive way is by drawing in international law, because actually that wasn't the case. And it's going to be less plausible to a domestic legal audience if I do it that way. So I think lots of us were making decisions to almost rein in maybe our kind of instinctive approaches. But I would say that for all of us, this was one project amongst many, right? And this was a particular project that we wanted to rewrite a judgment, engage with the judiciary, hope to have some impact on legal education in particular. But it doesn't preclude us from doing other things. And I think the more transformative element that did come out of it was and I hope you guys find this too, but it is about the network actually. That a lot of us were friends and sort of aware of each other's work, but it was the first time that we had really made a coordinated effort to actually bring together the feminist legal Northern stroke Irish academic community. And that's led to all sorts of productive offshoots that have, tried to engage, I think, in more radical or transformative ways.
Those connections seem to have been really important and really long lasting. I think it would be really useful just finally, as we're about to embark on this International Criminal Court project, do you have any advice? Anything that you wish you knew before you embarked on your judgment writing process or the bigger project?
I think don't be afraid to. I mean, the few things I would say, yeah, demystifying judgment writing. Okay, so we're all able to do it. The other thing I think is don't be afraid to reach out to people. So I was I was pleasantly surprised by the level of engagement we got from the Northern Ireland judiciary, and indeed the Chief Justice Declan Morgan, he was giving a lecture down in UCD about 2 years ago, and totally unprompted started talking about the Feminist Judgment Project and about 2 of the judgments that we had rewritten. So, and then when I was rewriting mine for our drafting workshop, I just speculatively invited the Commissioner for Public Appointments, because that was, key issue, and he came along, and I mean, people's willingness actually to say yes. So I think be bold in terms of just ask people. The level of engagement was fantastic. The network, absolutely. I mean, the value of the process is enormous, and that will be productive in all sorts of ways, even after the project has been published and gone to bed. And then actually, just on a more legal point, when I've written a book recently on women's rights in armed conflict under international law. So this is kind of the ICC jurisprudence is part of what I do. And one of my conclusions was that I felt that there was a real underdevelopment of the potential of Article 21.3, which has human rights as a source of law for the court. That was very underdeveloped. It tended only to come in at the reparation stage. But it did seem to me that there might be potential to have that more developed understanding of equality that we find in human rights law, particularly under CEDAW and elsewhere, that there might be more potential for that within ICC judgments. And that might be a way to kind of plausibly revisit some of the judgments as you will. So.
Thank you so much for your insights, Catherine. We really appreciate hearing from you today.
Pleasure.